Welcome to Legal Lines. My name is Tom O'Shea, the host of this program, brought to you by the York County Bar Foundation. My guest today is attorney Seth Eric Springer, an attorney in York, Pennsylvania, who happens to be the chair of the Family Law section of the York County Bar Association, and our topic is the Protection from Abuse Act. So welcome, Seth.
Thanks for having me, Tom.
And like I said, our topic is the Protection from Abuse Act, a very serious subject. But I'd first like you to tell us, what is the Protection from Abuse Act?
Well, the Protection from Abuse Act is a statute that protects victims of abuse perpetrated upon them by members of their family or members of or persons they have an intimate relationship with, be it a boyfriend or girlfriend, and also in instances of same-sex couples. It's only available to those persons.
I think that's an important thing for people to know. In many states, I believe that you'll hear on TV or something that somebody's going to get a restraining order for someone to stay away from them. In Pennsylvania, that would be a protection from abuse order, but it's limited to family members, as you point out, or people who have been involved with one another in some intimate relationship.
Yes.
Is that it? So it would apply clearly, and in most cases it applies to what we would call domestic violence.
Yes.
Okay. So it would clearly apply to a husband and wife situation. It could also apply to a couple that lived together but never got married.
Yes.
Okay.
It also applies to children, as long as they're related by blood or by marriage. It can protect them against abuse from other members of the family, even if it isn't their parents necessarily, if it's like an uncle, an aunt. So it is available in those situations as well.
So if someone thought they needed a protection from abuse order through the court system, the first thing they should know is whether or not they are in the type of family relationship that is protected by the Act.
Yes.
And that would include husband and wife, parent and child, parent and stepchild or step-parent to child. It could also include brothers and sisters.
Yes.
And other close family members. But it wouldn't apply like if you had a neighbor who was being abusive.
No, it wouldn't apply to a neighbor who was being abusive, but it would apply to a boyfriend-girlfriend situation.
Okay, so or former girlfriend-boyfriend
Yes.
situation, as many of the times that it would be. So the Act itself really is limited in the scope of who can be protected.
Yes.
Okay. And then it goes into protection from abuse. Now, there has to be a definition then of abuse.
Yes. The Protection from Abuse Act covers abuse that's either physical in nature or actions that intimidate the other person into believing they're in imminent harm of serious physical injury. An instance of this would be somebody holding a gun and saying, well, I'm going to shoot you now. Even if they don't point the gun or they don't shoot, I would make an argument that that's putting the other person in an imminent fear of serious bodily injury.
And you are using the word imminent because if somebody would say, I'll go get a gun and I'll shoot you someday, that might not be imminent.
Right, and the open-endedness of that threat doesn't really may not lead to the court entertaining the petition for protection from abuse and ultimately entering a protection from abuse order.
So with respect to the abuse itself, my understanding is it needs to be some type of serious abuse or threat of serious abuse.
It needs to be physical injury. The scale of seriousness of the abuse isn't so much at issue as long as you've got somebody who's physically abusing another person and they meet that relationship test. So for instance, if you've got a husband or a wife for that matter taking their spouse and shaking them around and throwing them up against the wall, while that might not be serious physical injury, there is ultimately physical contact and abuse.
And I believe part of what they look at is the element of fear.
Yes. And the Protection from Abuse Act protects people who are in imminent fear, or a reasonable imminent fear of future abuse, which is to say they're going into court saying that they've been abused and that they think it's going to happen again.
All right. And then what does the act itself do? I mean, if somebody is in a domestic violence situation, what's the benefit of getting a protection from abuse order?
Well, the benefit is it prohibits contact. If there is a protection from abuse order entered, it prohibits contact between the abuser and the victim. So whoever was the perpetrator of abuse is forbidden to contact the victim, the abused, either directly or through third-party channels. So you eliminate the intimidation or the harassment aspects of that abuse, because the court's essentially saying to the perpetrator of abuse, you are to not contact this other person. And these orders can go up to 3 years in length.
So it's basically the same as what many people would refer to as the restraining order that I mentioned a few minutes ago, where basically you're restrained from having contact with the other person.
Certainly. And there are other aspects of abuse that also fall under the Protection from Abuse Act. For instance, false imprisonment can be interpreted as abuse.
That's a good point, because most people, I believe, don't understand the concept of false imprisonment. Can you tell us what that is?
Yes, it's restraining someone else without their consent. Now, we're already assuming that they meet the relationship test, in that they're either a parent or a familial relationship, either by blood or through marriage, or they're a boyfriend-girlfriend. In these situations, you would have one of the couple, either the boyfriend or the girlfriend, physically restraining the other person and keeping them from leaving either a residence, which is typically the case, or even a public place against their will.
So I've seen situations where somebody will like block the door and say you're not leaving, or lock someone in a bedroom or something like that, and that's would fit the definition of false imprisonment.
Yes.
And I've actually I know I've seen situations where people stand outside a car and basically prevent the person from leaving the vehicle.
Right.
And that could be false imprisonment. And the Protection from Abuse law would find that as abuse, even though there might not have been any physical contact.
Yes.
And I believe stalking, I think you mentioned that, is covered by the Act. Can you tell us what that is?
Yes. The stalking or harassment of one individual by another who meet the relationship test needs to be a course of conduct. It can't be a single incident, because that, of course, wouldn't fit the definition of harassment or stalking. But, for instance, if you have an ex-boyfriend who is constantly following their ex-girlfriend, and the ex-girlfriend becomes intimidated by it and has that fear, again, you need that fear, they can certainly go into the Protection from Abuse office located at the Judicial Center in York County, and they could file a petition for protection from abuse based on that set of circumstances.
Okay, so stalking is covered by it. I know that I believe any form of sexual abuse
Yes.
would fit the definition of the Protection from Abuse Act, and that would also be the reason for the court to grant such an order, which would basically, again, be similar to a restraining order where the person has to stay away.
Yes.
Now, recently, as I understand it, the legislature created another law that's similar to the Protection from Abuse law. Can you tell us what that is and how it works?
Yes, that would be the Protection from Sexual Violence and Intimidation Act. And
That's a mouthful, so can you say it again?
I'm sorry, that is the Protection from Sexual Violence and Intimidation Act.
Okay.
And that became effective July 1st of 2015. And that piece of legislation was essentially a gap filler to protect people who didn't meet the relationship test under the Protection from Abuse Act, which is to say, if you had a neighbor that was harassing your child, in that situation, you don't meet the relationship test under the PFA Act, the Protection from Abuse Act. But the Protection from Sexual Violence and Intimidation Act doesn't have that relationship requirement. So in the instance of harassment or intimidation, you could request an order from the court based on that order protecting from intimidation, which it would require the child to be under 18, but it would prevent contact between that neighbor and that child. And they, similar to the Protection from Abuse Act, are available for terms up to 3 years.
Now, in the second segment of this program, we'll talk about the procedure to get a PFA order. So let's skip that right now. But ultimately, what is the person going to obtain who gets a protection from abuse order? You said that it could be no contact up to 3 years.
Certainly. And similar with the Protection from Sexual Violence and Intimidation Act, we touched on the intimidation, but the sexual violence aspect of that, for instance, if you had coworkers and one of the coworkers was sexually harassing or abusing another coworker, you wouldn't meet that relationship test under the Protection from Abuse Act, but you could file for a protective order, protection from sexual abuse, under the Protection from Sexual Abuse and Intimidation Act, because the relationship test is different. Now, under either one, it would again prevent contact from the abuser to the abused, even through third-person channels. But the court can also, in the instance of perhaps a couple that's getting divorced, the court can order that one of the parties leave the marital home, maybe that one of the parties provide something that is akin to that residence for the abused party. If the abuser has any firearms or weapons, the court would require them to relinquish those firearms. They may be able to hand them over to a third-party intermediary, or they would have to hand them over to the sheriff's department. If they don't have immediate access to them, they have to provide within 24 hours an affidavit stating what weapons they have. They could also require the parties to reimburse for certain things.
Well, any medical bill that would from the abuse would be one of the things.
Certainly.
Sometimes legal fees for going through the process.
Well, the legal fees for a protection from abuse petition are typically assessed on the defendant if there is a finding of abuse. Actually, pursuant to the statute, they can't assess the fees on the plaintiff or the petitioner in these actions.
Okay. But the bottom line is that when someone gets a protection from abuse order, they're going to get an order that the other person cannot contact them for any reason.
Typically, unless the parties share a child.
Okay.
You can have limited contact orders entered where the court will say there's no contact allowed between the abused and the abuser except for the purposes of custody.
Okay. And even in those cases, the court can fashion it as to what type of contact. I believe I've seen cases where they'll say, well, they can communicate regarding the children, but it won't be in person. It'll be by phone, or it'll be by email or text messaging or some electronic means, so that the people aren't basically being abusive to one another in their presence of each other, or even sometimes even they'll limit it so they can't even be telephone contact, but it would have to be by text or some type of recorded means so you could see what was being said.
Certainly. The court has broad discretion when there's a finding of abuse,
Okay.
and their objective is to prevent future abuse.
Okay, and we're going to leave it at that right now. We're going to come back in a few minutes and discuss about the procedure to get a protection from abuse order. This is Legal Lines. Welcome back to Legal Lines. My name is Tom O'Shea, and my guest is attorney Seth Eric Springer, an attorney in York who handles many family law cases. In fact, he is the chair of the family law section of the York County Bar, and our topic is the protection from abuse law in Pennsylvania. So welcome back, Seth.
It's good to be here, Tom.
And during the break, you gave me an interesting statistic, and I'd like you to share that with our viewers.
Certainly. It was relayed to me that in 2015, there were 15 domestic violence deaths, or deaths that are attributable to domestic violence. Now, these also include suicides, but all those 15 were attributable to domestic violence.
Right. So, and that's the deaths, and there are many other cases where there's been serious bodily injury, et cetera, where and that's what we're dealing with here, is
Yes.
a way to prevent that.
Yes, I was just in York County, and part of the objective of the Protection from Abuse Act is to prevent against the escalation of abuse, which you can typically see in these relationships.
Okay. Now, in the first part of the program, we talked about what the Protection from Abuse Act covers and what it will do. But let's talk now about how a person would get a Protection from Abuse order. So the very first question is does someone absolutely have to get an attorney to file for protection from abuse?
No, they don't. You can go to the Protection from Abuse office, which is located at the Judicial Center in downtown York, and you go to the PFA office, the Protection from Abuse office, and you can file a petition for protection from abuse. There are people there that will assist you in filing that petition. But I would greatly encourage anybody who is considering filing for a protection from abuse order or filing a petition for protection from abuse, I would encourage them to look into what's called a victim's advocate, and they're available through Access York.
Okay, and you gave me the number for Access York, which we can give to our viewers. It's area code 717-846-5400. So that would be Access York. And can you briefly tell us what Access York is?
Access York is an organization through the YWCA that assists victims of abuse in developing a safety plan and filing for a protection from abuse order. They'll assist them in the actual drafting of the petition and making sure that all the relevant facts get in front of the court. A lot of times when you've got a person who's experiencing domestic abuse, they're in trauma, and they don't have the mental wherewithal to remember or the mental wherewithal to properly draft the petition, whereas the victim's advocates at Access will assist that person in working through the trauma and getting all the relevant facts that the court needs to hear in order to grant a protection from abuse order.
So if there is someone who is a victim of domestic violence wants to file a petition for protection from abuse, they should first contact Access York?
Yes, they can go to the PFA office,
Okay.
but ultimately the number that you just given is at the PFA office, the Protection from Abuse office, and I would recommend that they immediately contact Access York.
And the Protection from Abuse office is located at the York County Judicial Center, which is at, 45 North George Street in downtown York,
Yes.
directly across the street from the Strand Theater.
Yes.
And it basically, if someone was going into the, I still call it the courthouse, it's technically the Judicial Center, but if someone is going in there, I think they first need to know that they're not allowed to bring their cell phone.
Right.
Okay, so
Nor any weapons.
well, obviously no weapons, but there is a security system in there, and people are not allowed to bring electronic gadgets, including cell phones, into the building.
Yes.
Okay, but once they get into the building, they can, and there are security personnel screening people coming into the building. So basically, a person can just ask, "Where's the PFA office?"
Yes, it's on the first floor, and they'll direct you right to the PFA
Okay,
office.
and then when someone gets to the PFA office, are these victim advocates available to help people fill out the paperwork?
They may be. That's something that they would have to call Access and coordinate with them, but I'm sure they would assign a victim's advocate because their interest is in getting this person the protection that they need immediately.
Now, this is free of cost also?
Yes.
And there's no filing fee to file one of these cases?
No.
All right, so somebody who goes to the PFA office, it's best to have an advocate help them put the paperwork together.
Yes.
And about how long does it take to complete this paperwork?
Well, on average, the paperwork takes about 2 hours to complete, but a lot of times, or many times, I should say, the court can move the paperwork in front of a judge, and then you'll have what's called an ex parte hearing that day. So upon the filing of the petition that same day, many victims of abuse are able to acquire a temporary PFA, something that's called an ex parte.
Now, what does ex parte mean?
Ex parte means it's only the petitioner going in front of the court, swearing under oath that what they're stating on the petition, the incidents of abuse, are accurate and complete to the best of their knowledge. And then the judge makes the determination based on the statements made in the petition and the verbal statements which back up that petition, whether in fact abuse has occurred. You don't have the defendant or the abuser at the court at that time, which is why it's only a temporary protection from abuse order. Ultimately, there's a hearing later on.
Well, let's talk about that, because ex parte basically means the judge is only listening to one side of the case.
Yes.
Which flies in the face of what many of us would say is a constitutional right to be heard.
Right.
Okay? So how is it that they can enter an ex parte order in these cases?
Well, it's based on the statements made by the abused, and also under the Protection from Abuse Act, there is a subsection that makes any false statements a criminal offense.
Okay. So there's a penalty if somebody makes a false statement, but also there has to be a hearing within so many days for the other side to have his or her voice heard.
Yes, within 10 days, you have to have a final hearing on the petition for protection from abuse.
So as I understand it, the reason the law allows an ex parte order, which is very unusual in most of our legal system, is because of the threat of abuse outweighs the time element of having a hearing where both people are come in at the same time.
Yes, and the theory is that if somebody's being abused to the point where they think that the abuse is imminent, again, we'd spoken about the victim of the abuse stating to the court that they're in fear that this is going to happen again, and this is continuing. And due to the nature of escalation in domestic violence, the court weighs these factors and has determined that an issuance of a temporary order outweighs the inconvenience that may be caused to the abuser in case the court ultimately finds that there is no abuse.
But to meet constitutional muster, there must be a hearing within like 10 days.
Yes.
Okay, where both sides get to be heard by a judge.
Yes.
And the judge ultimately makes a decision.
Yes.
Now, if someone is going to the PFA office to complete the paperwork, to file one of these petitions, what do they need to bring with them? What do they need? Any addresses for people? Do they need to give accurate statements as to what occurred on what date? You know, what do they have to tell the people who are helping them put the paperwork together?
Ultimately, it's up to the court to decide the veracity or the truthfulness of the petition. What I always tell my clients or people that are looking for protection under the Protection from Abuse Act is the more you can substantiate the abuse, which is to say you give times, you give dates, and you give specificity as to what happened. You don't say that perhaps your boyfriend threw you into the wall or your girlfriend threw a pot at you. You say what pot. You say where you were. You say what time it was. And that minutia of facts lends credence to the veracity or the truthfulness of those statements. Where ultimately, when you come to the Protection from Abuse hearing, the defendant can rebut those statements.
All right, well, let's move on now. Somebody files for the Protection from Abuse. They file a Protection from Abuse system. They meet with a judge for the judge to determine whether or not to grant the ex parte order.
Yes.
Now, if the judge grants the ex parte order, immediately in effect is an order that says there's no contact.
Not only that, if the parties live together, the abuser is ordered to leave that residence.
Okay. So, and how does that person know to leave the residence?
It's typically served either by a police officer or by the sheriff.
And they're pretty prompt about doing that.
Typically that same day.
Okay. So the sheriff's office might then deliver the notice to the defendant that says, you're accused of this. You have to leave the house until there's a hearing, and the hearing will be on a certain date.
Yes.
And you're not to contact the petitioner, the person who filed, during that 10-day period.
Yes.
And then what happens then? There's a hearing. So explain the hearing process.
Well, ultimately, you'll go to court for the final hearing on the petition for protection from abuse, and the petitioner who's making the statement is asked to address the court and again relay the abuse that had been perpetrated against him or her. After they have done that, the defendant is allowed to rebut the statements that were made in the petition and the statements that were just made orally to the court. And then the court has to ultimately weigh whether they think the abuse had occurred.
Okay. So there's basically a trial or a court hearing.
Absolutely.
In front of a judge. Now, at this point in time, should people have attorneys?
I would recommend that they do. Now, they don't need to, but an attorney in these situations will be able to get drilled down to the facts and perhaps find inconsistencies in statements either made by the petitioner or the defendant. Sometimes there are petitions that may not be accurate, and a well-trained defense attorney would be able to find those inaccuracies and exploit them.
Okay. But, most people are very nervous when they go to court. And so when, and this is a full court hearing. I mean, people would get on a witness stand, get sworn in.
Certainly.
There's a court reporter taking down every word. Everything that's said is subject to cross-examination by the other side. And basically it's testimony in a court hearing.
Yes, and perhaps more so in situations of domestic abuse than other court cases, the parties, typically the abused or the person claiming abuse, alleging abuse, is under tremendous emotional stress because of the relationship that they have with the abuser. Perhaps there's children involved, and a lot of times the abuser may think that taking this to court isn't worth the trouble, or a lot of times I've had situations where somebody has taken a petition for protection from abuse to court, gotten an order, and then just disregarded the order under the auspices or thinking that this other person really loves me, and this is just something that happened that's a one-time event. But I can assure you through my own experiences that when I've had clients that have come in and told me about physical abuse, and I've recommended they go and pursue a protection from abuse order, and they haven't, most of those clients have ultimately come back to me saying that they've been subsequently abused. The abuse simply doesn't stop until there's someone else, and in this case the court, that will step in and offer the protection that the abused needs.
So when the judge ultimately hears the evidence, the judge will weigh whether it's more truthful that it occurred than not and make the decision, which could include no contact for up to 3 years.
Yes.
And I know that there are ways that, and I'm going to speak briefly because we only have a few seconds left, that people can actually consent to the PFA order and say, I will agree to no contact, but I never committed the act, and the judge will accept that as a way of keeping the parties apart.
Yes.
And we're out of time now. My guest today was Seth Eric Springer, an attorney in York. The topic was PFA law, and this is Legal Lines.